This is Michael Popok, Legal AF, with some new developments in the E Jean Carroll second case against Donald Trump for defamation and now punitive damages to exceed $10 million based on the comments that Donald Trump made at the CNN town hall, the gift that keeps on giving, where he attacked her once again as a wacko who made up the entire story and other attacks on her character. We have a development. We reported 2 weeks ago on Legal AF that the lawyers for E Jean Carroll, Robbie Kaplan, had filed a motion for leave to amend the original lawsuit that she had filed for defamation for statements Donald Trump made when he was president. That's the case that stayed in the starting blocks, while the second case related to the same type of defamation, but after he was president, and was just Citizen Trump, went forward all the way through jury trial and jury verdict, a jury returning two conclusions, two verdicts. One, although they found that E Jean Carroll, under the elements of the statute at play in New York, was not raped, she was sexually abused. So said all 9 members of the jury. And by Donald Trump denying that he knew her, met her, ever met in Bergdorf Goodman's, and the rest, he had defamed her because something really bad and untoward happened in the dressing room at Bergdorf Goodman's in April of 1996. So says the jury. And whether you call it sexual abuse or you call it rape, there's no big major moral or legal difference between the two things. We're not talking about crimes at this moment. We're talking about civil claims. That's what happened in E Jean Carroll 1 with those findings and a jury verdict form to reflect it, including the $5 million. Why are we still talking about E Jean Carroll? Because he defamed her again. At least that's the allegation that she's made. At the CNN town hall, just a day after the jury verdict was returned in May, Donald Trump went up there, with a raucous pro-Trump crowd packed by CNN with Trumpers on purpose to make good television. He then used the opportunity to attack E Jean Carroll once again. Said she was a wacko and crazy, that he disagreed with the jury verdict because he never met her, didn't know her. He called it hanky-panky, that there was no hanky-panky, again, trying to demean her, and the rest. That is defamation again, because the jury found that something really bad happened in that dressing room, not what Donald Trump is saying, which is, I wasn't there, I didn't know her, this never happened in a public place at Bergdorf Goodman's. It's made up, a figment of her imagination. She's a hoaxer, she's a charlatan, she's trying to shake me down. All of those things. That is defamation because the jury's already ruled that he did something really dark and bad in that dressing room against her and violated her as a sexual abuser. Now, in order to get this new case of punitive damages out of the starting blocks, the lawyers for E Jean Carroll made a really good tactical decision. They said, hey, we already have a live case that's now ready to proceed because some of the appellate issues, some of the appeal issues about whether Donald Trump can or can't be sued in his capacity as a president when he defamed her have been sort of resolved to allow the trial to move forward. So we call that trial Carroll 1, Roman numeral 1. And their argument is, let's just amend the lawsuit, the complaint, the first pleading in a case. And everywhere where it said rape, we just put in sexual abuse. He sexually abused her, he sexually abused her, he sexually abused her, instead of rape, the R word, all the way through. And then he defamed her at the CNN town hall when he denied knowing her, calling it a hoax, calling her a charlatan, and saying other mean and defamatory things about her. That's the case. And so there is a pending motion for leave to amend that lawsuit. The advantage to keeping it in a new law, in the old existing lawsuit instead of a new lawsuit, is really timing. Most of that case is already over. The discovery's done. The depositions have been taken. There's just a new short set of depositions, maybe a week's worth of discovery about what he did at CNN. That's all you need. 2 years of discovery has already been done. Now we're just down to, that one set of comments over several minutes at CNN. That's a very short thing to do and get right to trial. Keep the case on its tracks, rolling down, keep the train rolling down the tracks. So, of course, Donald Trump hates that. And so he uses, whenever he has ridiculous arguments that have no chance of winning, he reaches into his bag of tricks and he pulls out, these days, Alina Habba. It's like a magic trick. Instead of the magician pulling the rabbit out of the hat, he pulls Alina Habba out, and he winds her up, and he says, "Here, go, file this ridiculous motion that has no chance of winning, or this opposing paper with the judge. And in this opposing paper that they just filed, we'll put it up on the screen, the opposition. You'll see, by the way, Joe Tacopina, who tried the case that lost and had him declared as a sexual abuser, he's nowhere to be seen on that piece of paper, right? He's either been fired or he's like, yeah, my name's Mud. Don't put it on there. So all it says is the law offices of Alina Habba, or Habba and Medallo, whatever her law firm is. She has an office at Bedminster. You could throw a golf ball from the Trump golf course and hit her office. And then she's got like a workspace that she rents in a WeWork type thing in Manhattan. I know, because I looked it up. And that's where she operates her law firm from. And so she filed this 25-page paper. And if you assume, as I always do and judges do, that your most important arguments go first, your argument you want to bury goes second, and then you end on your third argument, her first Roman numeral in her moving paper says, don't allow the amendment because it's tremendous prejudice to Donald Trump. Tremendous prejudice. And then she literally uses not literally, but she uses like kitchen magnet poetry. I mean, they are words. They are in some semblance of an order, but they really don't make any sense. That for her to be able to argue with a straight face that there's somehow prejudice by him now having to defend a sex abuse is now a defamation case, as opposed to rape is a defamation case, makes no sense. In fact, it's less prejudice because they have the right to file a new lawsuit. So the comparison is not going to be, for the judge, in the judge's mind, comparison is not going to be no lawsuit at all versus this amendment. It's going to be they have the right to file their own new lawsuit based on what just happened at CNN. And they can file that for the next 2 or 3 years on the statute of limitations. And that would give them the right to do an entire new case with an entire 1.5 or 2 years of discovery and depositions and document exchange and everything else. And it'll probably likely be assigned to the same judge as a related case, Judge Lewis Kaplan. That's what he's comparing it to. So you'd rather have a brand new case filed where you're going to go off for the next 2 years into discovery, or you just want to do a week's worth of extra add-on discovery in the original case that was filed? See, that makes no sense. So take Roman numeral 1 of her argument right off the board. And then you go to Roman numeral 2, which is usually the one the lawyers like to bury. Like not me particularly, but lawyers like Alina Habba. And Roman numeral 2 says that the argument in Roman numeral 2 is that they shouldn't grant the motion for leave to amend because the amendment is futile, meaning under the law, it's going to lose as a matter of law because the jury found there was no rape. I mean, you got to be trading in magical thinking to think that that was a good thing for your client. It's the best thing that happened. The jury found no rape. Right. The jury found sexual abuse. The only reason the jury didn't find rape is because because E Jean Carroll was a little bit cloudy, understandably, as a victim, a little bit cloudy about what part of Donald Trump's body was inserted into her private parts. She said she didn't look and she couldn't tell if it was his you-know-what, or it was his finger. And so the jury was like, all right, well, based on this kind of conflicting testimony, we'll say it was his finger, so that's sexual abuse and not rape. That's it. There's no it doesn't cover Donald Trump in glory. Setting aside the difference between his member and a finger, the fact that the jury found, oh, you're right, sir, you didn't rape her, you sexually abused her. That's like, who cares? That's basically the same thing. It is the same thing. That's the argument. And the defamation, when you say nothing bad happened, he denied that he raped her, but he didn't deny it in those terms. He denied it in the terms of, I don't know her. She's shaking me down. This is made up. I never met her. Then the photos came up where they met. I never shop at Bergdorf Goodman's, and there was the pictures of him shopping near Bergdorf Goodman. And this didn't happen. And it was hanky panky if it did, or I took her, or whatever his weirdo, disgusting phrases he used to describe that event. That's defamation. So you got it'll be futile, Your Honor, because the jury already found that my client didn't rape her. Right. Good news for the rest of the world. They found you sexually abused her. It's basically the same thing. So you got that going on. And then in the last argument they raise in their is it's not defamation by law. There's a legal defense to the comments he made at CNN. But he was just fairly reporting what happened during the trial. He was just fairly reporting that the jury found I didn't rape her. Right. But the jury found you sexually abused her, and that the jury found that you defamed her because you denied you had no alibi. Right. In other words, Donald Trump's trial wasn't about, are we going, him saying, I didn't rape her, I sexually abused her. That wasn't the trial. The trial was what happened behind that closed door of the dressing room at Bergdorf Goodman's in April of 1996. And the jury concluded, after listening to 11 witnesses and all the documents, that at least sexual abuse happened under New York law. That's what happened. So now you can't say, hey, great news, I didn't defame her because, see, jury said I didn't rape her. I mean, that's leaving out all the rest of the jury findings in order for you to reach that conclusion. And he certainly, if he wants to say something about the trial, he can say it like the jury. This is fair reporting if you're trying to get underneath that defense. There was recently a trial. Yesterday, a jury returned a verdict. In that verdict of 9 people, they found that while there was no rape, there was, under New York law, sexual abuse and defamation as a result of the denials by Donald Trump. That is an example of fair, accurate reporting that will put you under a defense for defamation. But when you give color and commentary around it, and you call her a crackpot, and you say she named her cat after a female body part, which she did, and she's a wacko and a hoax and all of that, you're not fairly reporting anything. You're giving your defamatory opinion, which gets you right back in jackpot to where you were before, which is you're going to end up owing E Jean Carroll a lot of money for punitive damages. So this entire motion or opposition filed by Alina Habba. Again, whenever you see Alina Habba filing something, think it's a crackpot legal theory that's probably not going to work. You can just read that underneath it. Like you can just read it. It's just like a watermark that's embedded in all of her filings, because that's what's happening. I report these types of events so that you get the facts based on my judgment after being a lawyer for 32 years and doing this kind of trial work in courts just like the one that E Jean Carroll is bringing the trial against Donald Trump in. And I do it at the intersection of U.S. law and politics about every day, but only on the MeidasTouch network. We put it all together on a show, on a podcast we call Legal AF, also on the MeidasTouch network, Wednesdays and Saturdays that I co-anchor. And then you can follow me on all things social media at MS Popok. And if you like this content, then give me a thumbs up. It helps bring the quantity and quality of the work that I do to you. And you can open up a dialogue with me on the chat. I've been known to jump back in, and we have a little chat going on about some of your observations or comments, and it's all appreciated. This is Michael Popok, Legal AF reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.